That's my understanding, Your Honor. Or
Yet one of
was.
the allegations in this warrant is that she failed to attend alcohol and drug treatment. Can you just clarify the allegation, Ms. Ashenfelter?
Yes, Your Honor. The UA was given the day before her last warrant to show cause hearing that this office was not aware of. After the jail mistakenly released her to when she was supposed to complete her 60 days. After that period, that's when she wasn't attending alcohol and drug treatment.
All right, thank you. I appreciate the
And Your Honor, I guess for additional clarification, so is this December 28, 2023 date correct then? Or should it be sooner? I mean, like, should it be earlier in the year? You said before the last show cause.
Yes, her last show cause hearing was December 29th.
Okay. Okay.
All right. What announcement is made at this time regarding these allegations, Mr. Watts?
Your Honor, regarding the allegations, the original warrant to show cause, in particular, the first allegation, my client acknowledges that she missed a meeting on December 27. She tells me she was unaware of a meeting on December 27. Perhaps more important, she acknowledges that she missed the meeting on January 12. As Your Honor may remember and may be aware, I'm sure is aware, Ms. Fry was sentenced to do 60 days minus any time she served on that particular warrant. Following the hearing on the 29th, the jail released her mistakenly. She frankly believed she was going to be arrested. She had a court date in front of Judge Lee and wanted to see how that court date was going to resolve itself before she turned herself in. It's my understanding she ultimately turned herself in on that to serve the rest of those days. As to allegation number 2, she would deny that she failed to attend drug and alcohol treatment as directed. In fact, her statement to me is that she has not missed a meeting with drug and alcohol counseling, including, and I asked her specifically about it, including the time that she should have been in jail and they mistakenly released her. As to the addendum, the original warrant, she denies that she was using either fentanyl or alcohol. Interestingly enough, Ms. Fry indicates that there was some testing done with Higher Ground. It was a mouth swab, not a UA. Hopefully those are not done at the same time with the same instrument. That would be nasty.
Well, I would hope not, Mr. Watts. All right, so we have only a stipulation here to failure to report.
Only a stipulation here to failure to report on the 27th, which she indicates she was unaware of, and the 12th she does acknowledge she was aware of, and did not appear.
All right. All right, we've only got a stipulation to one aspect of the warrant to show cause. Ms. Norris, does the state wish to present evidence in support of any of the others?
Your Honor, if we were, the state would need a continuance to get the individuals from Higher Ground regarding the UA or drug test, and also for the treatment information. It's my understanding that Ms. Ashenfelter has emails regarding same, but the person that she was conversing with is not present today. And state's request is for full revocation of Ms. Fry's probation.
Of course it is.
Or would be.
Watts, your argument here is that when she appeared for Judge Lee's court, which she had an affirmative obligation to attend, that's turning herself in? I mean, is that how that happened?
She could well have not appeared to Judge Lee's court. She did so, and did so knowing, and I'm assuming here, and I haven't talked, that she was arrested at Judge Lee's court, and I fully understand that. Yes, I think that's turning herself in. She could well have skipped Judge Lee's court. She went to Judge Lee's court knowing full well that she was going to be arrested when she did so.
I understand your position, counsel. Thank you. Ms. Fry, at this time, the court will address you personally, and I'll ask you if you have any statements that you wish to make in mitigation of punishment or anything further that you would like to present. Ms. Fry?
Yes, Your Honor. I'd just like to say in the beginning of this, I did have a severe addiction problem. I have struggled with addiction. I've seeked out treatment. I haven't been using. I have over almost 4 months clean now. I did turn myself in at Judge Lee's court date. I was aware by my attorney, Darren Patterson, that when I did appear, I would be arrested. So I made that obligation to go. I do have a full-time job. Outside of this, I have a relationship with my children. I am doing my treatment. I have full obligations to continue my corrections and do what I'm supposed to be doing. I should have reported on the 12th. I was afraid of being arrested when I would walk into her office. I just wanted to make sure I got my job, my treatment, and my children taken care of before I finished my sanction.
Very well. Thank you, Ms. Fry.
Your Honor.
I agree with Mr. Watts. The court's not going to consider the alleged drug use or the failure to complete treatment. We don't have evidence before the court. But what we have is a failure to report to her officer after she was let go from the jail substantially earlier than she was supposed to be due to some computation or paperwork error at the jail. I guess under those circumstances, Ms. Fry, if they came to you and said, we're going to go ahead and let you out, that you would just accept that gladly, accept their mistake, knowing that you hadn't served your sanction time. But I certainly can understand why you would accept it and be released to the community. But what the court doesn't accept or understand, Ms. Fry, that knowing the precarious position that you are already in, after all, it was a very close call for this court whether you were to even be given another chance, even with a 60-day jail sanction, the last time we were in court. And you appreciated that last chance so much that when you had a scheduled appointment with your community corrections officer after being let out of jail early, you didn't go. And why didn't you go, Ms. Fry? It's because you thought you might be arrested on a warrant or legal process if you went to her office. Well, I sure would have expected that's exactly what would have happened. You made a decision, as you have all along, to avoid responsibility, not be accountable for your actions, and make your own decisions about what you want to do, thinking that the system will never really do anything about it. Not anymore, Ms. Fry. You've had all the chances that you deserve and then some. Their probation was set up to be an alternative, a structured alternative to you doing your prison time. But you didn't choose probation. You would rather apparently choose the prison time rather than to successfully complete, after numerous attempts to do so, your probation in this case. So this court will, based on the failure to report to her officer as scheduled on January 12th, will revoke the probation outright of Janie Fry and order her to serve the remaining balance of her sentence in Department of Corrections, with all accrued jail time credit to be reflected by the journal entry stemming from today. It appears to be somewhere between 70 and 80 days. And that should be reflected, again, by the journal entry which stems from today's proceedings. According to the court's original sentencing order, I will reannounce the post-release supervision period at 24 months. The good time credit that she can earn is 20%. And will waive any further bids assessments in the case due to the court's imprisonment order that I'm entering today. All right. I'm going to remand her custody back to the Butler County Sheriff's Office until her custody can be transferred to the Department of Corrections. Ms. Norris, is there anything further the court needs to address?
No, Your Honor. Thank you.
Mr. Watts, anything further at this time?
Your Honor, would the court consider a motion to modify the time at this point?
I consider that as part of my announcement of the order, Mr. Watts. She just simply hasn't done what this court believes she should have done to earn a mitigated or reduced sentence. The court believes that the original sentence should be imposed in the case, and so your request for downward modification of the sentence is denied. Again, I'll remand her custody back to the sheriff's office, to the jail, until she can be placed in Department of Corrections custody to complete her sentence.